Tonight is an opportunity for us to discuss immigration. As I always say, immigration is life. As I said from my intro, I'm going to look at a very unique topic tonight. I'm looking at those who have lived here for 20 years or less. Those who have had problems with the law, some convictions here and there, what we call legal limbo. I'm going to look at two cases. When I come on this platform, I don't speak fiction. I speak facts. So I'm going to take my time to educate viewers, to guide them, those who have lived here for 20 years or less, how they can make application under paragraph 276 ADG according to the immigration rules. So I'm going to take my time to teach how people or those who have lived here continuously, unlawfully, illegally for 20 years or less, how these people can regularize their stay, including those who have had deportation orders imposed on them, those who have had problem with the law and have had some convictions, and they are now in what they call legal limbo. You are hanging in the balance. This is the opportunity for you to have free legal advice. And I'm sure that most of you out there watching me and listening to me tonight know someone who has probably lived here for 20 years or less, who have had problem with the law, and some of you have even had applications being refused because perhaps you were apprehended at the workplace because you were working somehow illegally, and because of that you were sentenced, and for one reason or the other, when you are now making new applications, or we are making application under paragraph 276 ADE, those applications are being refused. Tonight, I'm taking this opportunity to educate viewers to know their right, to know the grounds on making those applications, so that they can attain success whenever they make those applications. But before I do that, I want to shout out to MC Chaka, my buddy, and who has been hosting the Q program. Tonight is his birthday. It's a very special day for him. I'm sure he's enjoying with his family now. And those of you who know him, this is an opportunity for you to shout out and wish him a happy birthday if you haven't already done that. Today is MC Chaka's birthday, so those of you who are familiar with him, or acquaintance and friends and family members, you can take opportunity of this announcement and wish him a happy birthday. But having said that, I'm now coming back to the law. I always say here that I am not a doctor. I don't give prescriptions, or I don't diagnose people of their sicknesses. And I'm not a pharmacist, so I can't give you prescription. I'm not a counselor, so I can't counsel you on how to manage your relationship and your marriage. But there's one thing for sure: I know the law. And whenever I'm here to teach the law. So tonight is your opportunity to have this free legal advice. And obviously, as I always do, I'm going to give viewers opportunity to ask questions. It doesn't matter whether your question does not relate to the topic I have treated tonight. I am still willing to answer those questions as long as it falls within my areas of practice, competence, and jurisdiction. Two strong words there. But having said that, I want each and every one of you to invite your friends and family members as I go on this short commercial break. When I come back, I'm looking at this unique topic: 20 years or less unlawful residence. When I say unlawful, you have lived here continuously and God has favored you. You've not been removed, you've not been deported, and you've been here continuously for 20 years or less. And you are still here, you have not made application under paragraph 276 AD, and I'm going to ask you, what are you waiting for? Those obstacles, those issues that you think that they are insurmountable, I am here to demystify and make them so simple for you to understand that you have a strong case to make a successful application. That's what I'm here to do tonight. So please, I want you to share the videos with your friends and family members. And I'm just going on this short commercial break. When I come back, I will take my time and I give the update of this 20 years lawful residence. There have been a lot of dancing and fighting in the immigration and even the Court of Appeal. And I'm here tonight to give you those updates and to make you to understand that the judges are on your side. If you have lived here for 20 years or less, the decisions coming out clearly shows that the judges are on your side. And therefore, this is an opportunity for you to take advantage of this free legal advice and make a move and make those applications that you ever thought was never going to be successful. I'm telling you, you have a strong case. So join me, and after my short commercial break, I'm taking my time to explain this to you. Don't go away. Please don't go away. you so much for your patience. As I said, tonight I'm just looking at this area of law under the immigration long residence. Long residence. But I'm going to look at specifically those who have lived here for 20 years or less. Obviously, when we talk about long residence, we are looking at paragraph 276 ADE. And obviously, it means that anybody who, for example, has been here for more than 7 years or more and is under the age of 18 or was born here and is at the age of 7, that person is entitled to make an application for leave to remain under the 10-year rule. Now there is a concession that those who were born here and 7 years, they can apply for indefinite leave to remain straight away. If you ever came to the UK and you spent half of your life here and you're at least 25 years of age, which means that if you have been here for about 12 years, which is half of your life, then you are also entitled to make application again for leave to remain under the 10-year rule. Now there is also a concession that on 2 consecutive applications you could now apply for indefinite leave to remain. An entire category of people under paragraph 276 AD are those who have lived here for 20 years, continuously for 20 years, unlawfully, illegally. Or those who have lived here less than 20 years, but can show that they have no families, they have no ties to return to if they are ever to be removed and sent back to wherever they came from, whether planet Jupiter. So tonight I'm going to take my time to gradually explain to viewers how they can make applications and be successful in those applications. But even more importantly, I'm also going to look at 3 or 2 case laws which has been dancing in the upper tribunal and then the Court of Appeal. And to explain to viewers that judges looked at this case very compassionately in the light of the fact that it is not an easy journey for one to live here continuously for 20 years. And in the course of that, some people will have to survive. And because they may work with other people's identity here and there, they may get convictions and be sentenced. Does that mean they are not entitled to make applications when they are able to evidence that they've been here for 20 years? And that's what I'm going to take my time to explain to viewers tonight. And I'm going to do this quite slowly so that people can follow it. Because this is one of the complex areas under the immigration. Because day in, day out, I am seeing applications that are being refused, Home Office making reference to people who have had convictions, and those applications are being refused. For the wrong reasons, obviously. And that's why you need to know the law and your right. So that when you are making some of these applications, at least you know what is required of you. But I always say here that whenever these applications are being made, we don't just rely on the immigration rules and the legislations, but we also look at the case laws. The case laws are very fluid. When I say fluid, they are ever changing because the courts, the tribunal, and the court system is moving very fast and catching up with time and giving interpretation, broad interpretation of the European Convention on Human Rights. And therefore, because of that, most times, even when people think that their problems are insurmountable, that they have a very difficult problems, that they feel that they cannot even make application because they have had convictions in the past, because they've had deportation order still live and pending. And the distinction here is that when you have a deportation order on you, it means that, for example, you've been sentenced for a year or more, and the Secretary of State has deemed it necessary that your presence in the United Kingdom is not conducive for the public good or for the public security. So under those circumstances, you are going to be deported. And that deportation order does not lapse. It stays there until the second time that you're able to make an application to give cogent reasons why that order should be removed or revoked. So it's quite serious stuff that I'm talking about here. And most times, when you have this deportation order pending, live, any application whatsoever that is submitted is automatically refused. So I'm going to look at what they call the legal limbo. People who have had this deportation order in place, sometimes for 10 years, and they are still in the system. They are not going anywhere. Restrictions here and there. Yet, they are not being able to make applications even though they have lived here for 20 years or more. And they are saying in legal limbo. Tonight, I am taking my time to explain how those of you who find yourself in that category can make successful applications. But going further, I am also looking at those who have lived here continuously for 20 years or less. It's a challenge. I can't imagine someone living here continuously for 20 years, living in shackles and shadow. It's quite pathetic. And that's why the law makes it clear that if God has favored you and you've been in the system up to that length of years, then of course the system recognizes that you should be given leave to remain because this place has become your home. I'm sure most of you, after living here for 20 years, if you came from Ghana or Cote d'Ivoire or Belarus or Russia or whatever country you came from, you probably, when you go back, you will not even know where you lived before. Most of your friends may have died or have moved or traveled to different parts of the world. So most times you lose ties. So you might have lived here for less than 20 years, but you have lost those ties. That gives you ground for making an application. So even though you have lived here for this less than this 20 years, but there are still strong grounds for you to succeed in that application. And I always say that when I'm on this platform, I don't speak fiction. I speak facts, which are backed by the law. Now, I'm looking at these two cases. Tonight, I'm looking at these two cases. And they are relatively new cases. And the reason I'm looking at these cases is that sometimes I get very appalled with some of these decisions where people have been refused because they've lived here for less than 20 years and they've made those applications. Or because they've had some convictions. When I say conviction, when, for example, you were working because you need to survive and immigration officers apprehended you, and one reason or other, they were charged for false identity or double identity, eventually sentenced for a couple of months, and then released after serving your sentence, and you still remain in the system. You then make application, and that same conviction is then relied upon to refuse your application, notwithstanding that you'll be here for 20 years. And then I ask myself, on what grounds do you rely on? Show me that law that support this case, that this such application should be refused. And that's why I'm going to take my time to quote these cases for people to be aware that some of these decisions are wrong. But you need to have the legal locus, the grounds, the authorities to challenge those decisions. Because when the 20-year rule, or for those who have lived here for 20 years, when these immigration rules were introduced in 2012, July, and in fact, this month is the anniversary, 10-year anniversary. That's why I'm doing this program. And coincidentally, it is MC Shaka's birthday, July. That's when this law came into place. So tonight, I'm looking at this law that has been in place. And obviously, cases that have gone through the tribunal and the Court of Appeal for the past 10 years, and how it has shaped the law gradually in favor of you. But you need to know you are right to take advantage of these cases that learned judges have concluded that if you are in that situation, then Home Office does not have the power and the grounds and the reason to refuse your application. But they will, unless you know you are right. And that's why I'm here tonight, trying to conscientize and enlighten people, for people to know they are right. Sadly, sometimes when I do this program, I receive all kinds of abuse because people don't want others to know they are right. Even when you are just explaining law to people, people still find it as a problem. But hey, I am here to help you. I am here to enlighten you. I am here to assist you so that you can know you are right. So I'm looking at these cases. Now, in showing that you've lived here for 20 years or less is always very difficult. Yes, I know. It is. Because it's an open secret that sometimes people end up working, obviously, to be able to survive. And the court and Home Office, they are aware. I am not here to condone people, to condone convictions, in other words, to support what is wrong, but I'm here to state the facts as they are. And I know that most of you find yourself in that situation. I'm not here to condone that it's wrong or it's right to do this or that. I'm just here to state the facts. And if you find yourself in that situation, I am just here to educate you, to tell you that you have a right to make the application, irrespective of this hurdle, obstacle that is standing your way. So, because it's very difficult for people to live here continuously for 20 years without sometimes working, without sometimes assuming certain identities for their survival, they end up sometimes assuming certain identities, sometimes working in some names, and eventually, sometimes some of them get apprehended by Home Office and are sentenced, and they get convictions. But when Parliament was debating this law, one thing that was clear when you read paragraph 276 ADG under the 20 years unlawful resident, it makes it clear that your residence in this country is unlawful. However, you need to show that this residence is continuous. So it means that if for one reason or the other you were working and you were apprehended, you assume the name of Kojo, though you might be called Anthony. Quite clearly, it doesn't matter how this has happened. What matters is that when you consolidate, when you accumulate all this period, does it add up to the 20 years that you are meant to rely upon to show that you have been here continuously? Because obviously, the law is blind to those who can say that they have lived here for 20 years but cannot show whatsoever evidence that in fact they have been here for 20 years. And the same law will support those who can evidence these documents, who can show that maybe 2 years ago, Home Office stopped me, I had this identity, they took my fingerprint, it showed that I am Kojo. And then the next time I was apprehended, it showed that I am Amma. And all this clearly shows that I have lived here continuously for 20 years. But the danger is that sometimes people fail to disclose some of this essential information. And what they don't know is that if you don't disclose some of this information, it means that you have failed to disclose material information or disclosure, and your application could be refused on that basis. That's one. Failure to disclose who you have been all these years. The second point is that if you fail to disclose, then it means that indirectly there are going to be gaps in your residence, your 20 years unlawful residence. And these gaps, last time I was talking to one client when I gave this example that he was telling me that, somebody that was born in this country, that obviously he was there when the person was born, he took pictures with the person. It's 20 years, and the judge is saying that he doesn't believe that he has been here for 20 years. I said, yes, the judge is right, because there are gaps in your continuous residence. Though they expect you to show that you've been here illegally, they also want you to show that there are evidence, documents to show that you've been living here. It doesn't matter, you can consolidate or accumulate whether you've been Mr. Sankara, Mr. Abudu, Mr. that, whatever it is. Once you can accumulate all this evidence to show that you are who you claim you are throughout these intervening periods, then of course you should be entitled to this 20-year rule residence or leave to remain. But I'm going to give these two case laws, and then after that I'll give viewers opportunity to ask questions. So when trying to show that you've lived here for 20 years, as I've said, we have the case called Al Ahmed versus the Secretary of State 2020 case. A gentleman from India who have lived here for many years is known by his GP by a name. He's known in the restaurant where he's working by another name. He has made applications in the past. He has been refused because Home Office was not convinced he has lived here for 20 years. And then eventually, he clocked this 20 years, makes application, and disclosing that the name he has been using to be working and be seeing his GP actually belongs to a British. And even as will be expected, Home Office refuses that application on the basis that how dare you assume false identity and rely on it and make application for your leave to remain. And this case went all the way to the upper tribunal. The decision was that 20-year rule is there for those who are living here illegally. And therefore, what is required for them is to show that they have been here continuously for 20 years. It doesn't matter whether they were working illegally or not, because the sole purpose of giving these people opportunity to make this application is that they have been here illegally anyway for 20 years. And therefore, the tribunal and the judges in their wisdom dismiss Home Office case and allow this gentleman's appeal on the basis that, irrespective of the fact that he has used other people's identity in accessing medical health care and being able to survive by working, the evidence clearly shows that he has lived here continuously for 20 years. This is not fiction. This is a fact. I've already quoted the case law. And this is a case that was promulgated in 2020 during the first lockdown. Now, currently, I'm going to also take my time to explain the new case law or a Court of Appeal case which was just promulgated recently. And here there are a lot of complexities here for someone who has been in a legal limbo. And I'm going to take my time to also explain to viewers, those who find themselves in that category, how they can make applications. But before I do that, I'm going to acknowledge viewers who are on this platform. It's always important that these viewers are acknowledged, because without them, I will be here talking to myself alone. And I always appreciate the fact that people are keen to join the show and to get this free legal advice. So if you are here and you want me to acknowledge you, if you can simply make a comment, I will be able to acknowledge you. Now I have Kwekuta Neku, Fred Asare, who are watching. Tonight I have Chilotam, Louisa Obuagu, who is also watching. I have Kufia Mountain watching currently. I have Highly Favored Priscilla watching. And Sina Kari, who is a regular member of this platform. I have David Bebley, who is also watching. I have Ernestina Kari, which I have already acknowledged. Good job, God bless you. I have Eno Frimpong, who is watching. Tomase Sava Grandfrey. Tomase is a francophone, my own cousin, who is also watching tonight. I have Kwajo Bobot, who is watching. I have Benjamin Sian Dudu, who is also watching tonight. I have Papa Pa watching. Vida Kutua is also watching. I have Tora Fimpon, it's a good evening. I have Ami Abiana Nelson watching tonight. I have Louis Antwi watching. Francis Adu Ajamai watching. Olisko Idrisu watching. Fred Asare and Endofupon. Alright, Margaret Bubbles, thank you for joining the show tonight. I have Nana Frema, a regular member of the show. Those of you, Francis Adu Ajamai, also watching. Matthias Saika watching from Austria, all the way from Austria. Wow, wonderful, great. So guys, those of you who are also watching from Thomas Berbon profile, I always say that try and migrate and come to the CITI Media TV. That is the epicenter. That is where all the action take place. So tonight, I'm gradually looking at those who have been here for 20 years. I know that this is an area that is quite complex. I know that even those people who find themselves in that bracket are so confused, quite rightly so, because some of them, they cannot even show how they have been here. They have been in the shadows. Some have had convictions. Some have had issues here and there. Some have been in legal limbo. They have had deportation orders imposed on them. But the Secretary of State, for one reason or the other, have not been able to remove them or deport them. These people are entitled to make application under the paragraph 276AD. And for those who have been here for less than 20 years and have broken ties with the country or wherever they came from, and those who have other issues, claiming that they have compassionate reasons to be considered. So sometimes when we say 20 years unlawful residence, it doesn't mean that you have to be here for complete 20 years. Because some of you have exceptional reasons. Some of you have compassionate grounds. For some of you, you are relying on the very Article 8. And tonight, I will take my time to explain a little bit of this Article 8, which obviously comes into this private life. Because obviously, when you're looking at the 20-year rule, you are looking at private life. How long one has lived here. So, I have looked at the case of Al Ahmed. I have looked at this gentleman from India who have assumed identities, who one reason or the other has made various applications in the past. He is known by the Home Office. His applications have been refused on several occasions. In the past, he has not been able to show how long he has lived here because he couldn't show the evidence. And because he was advised by a good lawyer, he was able to show that, well, I have accessed medical care in this particular name. I have worked in this particular name. This is not my name, but this shows that I have lived here. My GP can confirm that he has seen me, that even now that I'm claiming to be this person, he is aware that on regular occasions I have visited that GP surgery with his name. And there comes the judges to interpret this law, which makes it clear that once one have lived here unlawfully, continuously for 20 years, then they should be entitled to acquire some form of leave to remain. And Home Office claiming that because this gentleman, by the sheer fact that he has disclosed that he has worked in a different name, disqualifies him under paragraph 276AD to succeed in that application. But the case quite clearly shows that he is entitled to leave to remain, irrespective of the fact that he has assumed these identities. Because the only essential thing one needs to show when one is making application for 20 years unlawful residence is to show the continuity of your residence. It doesn't matter how you've been able to survive these 20 years. You need to be able to show continuously. So if at some stage you've been considered as AMA, and currently I have some of the cases that we're dealing with where one has claimed different nationalities here and there. I'm going to come to that new case where I'll be able to give confidence to those who have had issues. So if you are looking at the continuity, then because it is unlawful residence, all these issues are supposed to be discounted or ignored, except that one needs to show that he's been here for 20 years. And once one has been able to show that cumulatively by looking at whether you have been AMA, Kojo, Ajwa, and putting everything together, which most people are terrified to do it. But I'm here to tell you that go and check this case out. It's quite clear. Because the danger is that if you fail, we have a client we are currently dealing with. He's been here for 20 years, but nothing to show. Absolutely nothing. Because if you are making an application of this nature and you can't show that you'll be here, whichever shape or form, then how do you expect Home Office to grant you that leave to remain? One, the very law says that you should show that you'll be here continuously, unlawfully or illegally, for 20 years. That does not mean that if you came here 2002 and now we are in 2022, that automatically entitles you to leave to remain under paragraph 276A. No, it doesn't. Because during the intervening period, you could have traveled abroad. You could have lived abroad for some years, for some months. Your continuity or residence would have broken because you would have gone abroad for some time. And hey, one will be asking, oh, I don't have papers. How will I be able to travel abroad? Oh, the law says that they are giving it to you because you don't have papers and you've been here for 20 years. Day in, day out, people are coming from Dover seeking asylum that sometimes they are unsuccessful. So if you could come in and seek asylum, whichever way, for convention reasons, then can't you also travel out and come back? So the law is blind to those of you who have been here for 20 years, unless you want to open the eye of the law to sign onto the evidence that clearly shows that you've been here for 20 years. And if you are not able to show that, then it means that under those circumstances, your application will fail. And most of you, because of the fear of making these disclosures, you don't send any document. Even though I'm aware that if you have charity organizations, if you have churches, if you have credible family members who one way or the other are testifying that they've known you for all these years and you've been living here, sometimes they add little weight to family members' evidence because they are not independent. And this is the challenge for people. Sometimes people will be asking, oh, I remember there was a time I was doing a fee waiver for someone who obviously is making a preparation to make application for 20-year rule. He's a lawyer. If I has disclosed that I'm working, are they not going to refuse my application? I said, yes. That is not a grounds for refusing your application. But of course, they can ask you to stop working. But the point is that if you are making a fee waiver, any income that you are receiving, whether from illegal source or from friends and family, you are meant to disclose it. Because it's part of your disposable income. But more importantly, if you are showing that you have been working, then quite clearly you have the evidence to show that you've been here. And absence, or if you don't have that evidence, if you don't have those documentary evidence, then of course, the danger is that this application is going to be refused. So you see, the fear people have, relying on the documents that will assist them in making the applications, and sometimes going empty-handed and getting these applications refused. Now, so let me catch up with this case of R.A.M. versus the Secretary of State, 2021 case. Now, I have already talked about Ahmed. I'm moving on to another case. The Ahmed is a case for this upper tribunal case. This very case is a Court of Appeal case, 2021, quite recently. And here I'm going to look at what they call the legal limbo. The legal limbo. Obviously, when you say something is in limbo, I'm sure most of us understand it. Where your feet is hanging in the balance. The Court of Appeal is saying that one feet cannot be hung in the balance. One case cannot be in legal limbo forever. There has to be a point where that person needs to be granted leave to remain. And this is about someone who have lived here for 22 years. And I'm going to give a short background of this case so that people will know that when you are here for 20 years, you are not in this alone. If one reason or the other, you have some convictions here and there, you are not alone. If one reason or the other, your record is blemished. One reason or the other, you have issues that remains stumbling blocks or obstacles for you to make. Some of you even have deportation orders. There have been several unsuccessful attempts to deport you. So I'm going to look at the human right, the European Convention on Human Rights. Haven't already looked at the fact that people who have been here for even less than 20 years, if they can show exceptional circumstances, for example, if they are severely sick, if they have cut ties, if their state of mind is such that if you are sent back home, there is no support system. Yes, and I know that sometimes they will say that, oh, you came to this country when you were an adult, you lived there throughout your childhood, and for that reason, we feel that you can say go back and reintegrate with your family. No, it's not true. The law doesn't say that. So if you have exceptional circumstances, but the most important thing in making these complex applications is for you to understand how to formulate your case. Because before I go to the legal limbo, there is a trick here that I want people to understand. When you make an application and you have been here for 20 years, they expect you to show how you've been here by putting in documentary evidence from different sources. But if you have been here for less than 20 years, caseworkers are not obliged to look at your exceptional circumstances, your compassionate circumstances. And I'm going to take my time to explain these two terminologies. It means that if you don't disclose it, you don't formulate your case, you don't present it in a way that a caseworker can relate to it, then it means that straight away, because you've been here for less than 20 years, that application will be refused. But there are applications that are going to be successful, even though those applicants have been here for less than 20 years. Because of why? They are exceptional reasons. Because of why? They are compassionate reasons. But these reasons need to be made clear to the caseworkers. They need to be adduced. They need to be presented in a manner that when the caseworker starts reading your case, your background, the sort of things you've been through, the kind of surgeries you've had, and the fact that perhaps your support system back home is no longer existing, and there is no one. Yes, even though it is not this country's responsibility to take care of you because that medical system is not readily available or more expensive. But the fact is that this present exceptional circumstances that the caseworkers needs to give reasons why they cannot give you leave to remain, even if you have been here for less than 20 years. When this case likely. So you are throwing this challenge to them. And obviously, most of these decisions, when they are refused, they give you right to appeal because it's human right application. And I have already explained to you how someone's application was refused, and the judges considered that the reasoning for refusing that application was wrong, the case of Al-Ahmed. Just because he has disclosed that he has previously assumed false identity. There are those who also have compassionate circumstances. They need to make this also clear. Because they've been here for less than 20 years. But their circumstances are such that some have had minor stroke, some have had mental illness, some have all kinds of sicknesses that requires a Secretary of State to show compassion. And in fact, sometimes if you want to present a good case, you need to even get expert medical report to show why it will be almost impossible for that person to live in the home country where he's coming from. You don't just throw your documents at the caseworker and expect them that miracle will happen. Remain in the church and be praying. No. We all believe in God, but this is the law. The law requires that you provide what is required within the confines of the law. I know miracles work, of course. But you need to meet the requirements. So you don't just throw your case there and keep praying. You need to present your case. Even in the Bible, those of you who are Christians, you know that when the woman came and started pleading his case to Jesus Christ, he showed compassion. So you need to plead your case. This is an application of biblical principle. Plead your compassionate grounds to the caseworker if you have been here for less than 20 years. Then of course, he's a human being. And even if he decides to throw away your case, the judges are there to look into it again. So you have the second chance. So this is my submission for those of you who have been here for less than 20 years and say want to consider making applications. And have any of these reasons. Moving on from there, I'm looking at those of you who have been in legal limbo. Deportation orders. Some of you went to prison for some time. You were sent to the detention center. And miraculously, you were released, because obviously what used to be called temporary admission, which is now bail, you cannot detain someone indefinitely. So some of you may have deportation orders, but one reason or the other, you've been released. You've been in the system. There's a legal limbo. You've not been deported for many years. You've been here, burden your family life, burden your private life. You clock more than these 20 years. And then, as I've already said, anyone that has deportation order in place, normally when you make applications, unless that deportation order is first revoked, it's automatic refusal. Any lawyer is aware of that. But the human right covers that grounds. So if you're in legal limbo, I'm looking at this case, new case, R on application of AM because of the anonymity order versus the Secretary of State 2021. This is a Court of Appeal case. A gentleman claiming to be hail from Belarus, having lived here for many years, sought asylum on 3 occasions, all refused. Since 1998 has been in this country. In 2008, sentenced to prison, custodial sentence for 10 months, and the reason being that he was working with Lithuanian documents. He had to survive. Having been arrested and sentenced, he was sent, after serving the sentence, he was sent to the detention center, eventually released. Unfortunately, in 2018, after 10 years, he said he had a problem with the law, convicted on the second time. Again, sentenced for weeks. With that previous deportation order still lingering in limbo. And when he decided to make application under this 20-year rule, as to be expected, Home Office are always waiting to refuse these applications. Application was refused. Tonight I'm giving background because I know that most of you find yourself in these scenarios that I'm describing to you, and I'm not giving you fiction. It's not a story. These are case laws. I'm only giving background. And therefore, it means, what this means is that if your situation fits into this case law, then you have a strong case of being successful in your own application. End of this story. That's all that it means, legally. So here, you find out that you are not in this alone. Because that gentleman had to survive. He had convictions. He served sentence. He had deportation orders. But under the 20-year rule, after he had lived here continuously for 20 years, and the fact that he came here at the age of 21, quite clearly, he had no support system if he was to be returned to Belarus. And in fact, his nationality was even in dispute. Again, this adds to the legal limbo. And therefore, when this application was refused, this case has gone all the way to the Court of Appeal. And the judges again has confirmed that on human rights ground, there is no legitimate aim to remove such a person. And the absence of being removed, all the lawyers know, is to grant that person leave to remain. So hey guys, you are not in this alone. If you have lived here for less than 20 years, if you have lived here for up to 20 years, if you have criminal convictions, if there are any hindrances that makes you feel that you don't have cause or good grounds or strong case for making application, I'm telling you tonight that if you have listened to me, you have a strong case here. You need to plead your case. I'm going to open the phone line soon because I'm coming to gradually coming to the end of my submission tonight. And again, I want to check those who have also joined us. I have Emmanuel Say, who has joined us, Matthias Saika. Now, guys, if this is the first time that you've joined us, we do this program every Tuesday in English, and then on Thursday, we do this in Chi for all the Ghanaians in the diaspora. So, tonight I'm doing this in Chi. On Thursday, this same program. Sorry, tonight I'm doing this in English. On Thursday, this same program will be in Chi, the same topic. We will discuss it extensively, give viewers the opportunity to call in and ask questions, because you deserve to know you are right. So hey, if you just join us, tonight I have been looking at 20 years unlawful continuous residence and your human right, or how to make leave to remain applications if you have lived here for 20 years or less. I'm not saying more because that confuses people. Because we know that when you have lived here for 20 years or less and you have compassionate or exceptional reasons or human right grounds, even though that is in the law already, because obviously the private life is all about Article 8, right to private life and family life. And I've also looked at those who have had convictions. You work somewhere, Home Office officials stopped you, police were called, you were arrested, you were convicted, and sometimes you even receive custodial sentence. You served your sentence, you now have criminal convictions, and you think that because of all these reasons you can't make applications. No, the law makes it clear that you are still eligible to make your application. You need to plead your case. So tonight I have looked at those who have been here for less than 20 years, up to 20 years, those who have had criminal convictions, those who have been in legal limbo with deportation orders on them. I have discussed 3 substantive case laws, both in the upper tribunal, promulgated in the upper tribunal, and then the Court of Appeal. And I have given viewers broad range of scenarios where they fit in and how they can rekindle their own cases and make these applications. They shouldn't be confused. Don't be terrified. You are eligible to make that application. So I'm going to open. I have Ed Bob Aka. Wow. Bob Aka, it's been a long time. Thank you for joining us on this show. Right. I think because today is MC Chaka birthday, I have all the vandals, moving around, on all the platforms. If I've already said that today is MC Chaka birthday, so I urge all of you to reach out to him and wish him happy birthday. He's been doing so much for the community. He's been entertaining the community. He's been doing MC job, and he's been supporting City Law Solicitors to translate the English to Twi for all our viewers to have the benefit of this show. So, MC Chaka, we shout out to you tonight. All right. So I'm going to open the phone lines. I haven't done the advert tonight, but very soon I'm going to do advert, because I need to advertise City Law Solicitors. This program is proudly sponsored by City Law Solicitors. So I'm going to open the phone lines, and then if you are watching from the screen, either from the YouTube or City Law Solicitors YouTube channel, or you are watching from City Media TV on Facebook, or Thomas Bebon, my own Facebook profile, you will see that the phone lines are on there on the screen. If you don't have any question about 20-year rule, and you have question about any area of law, as long as it falls within my area of practice and jurisdiction and competence, I'm going to take my time to answer your question for free. This is free legal hour. So I'm taking opportunity of this after mentioning the phone line, so that we can discuss a little bit about City Law Solicitors, who we are and what we do. The phone lines, even though they're on the screen, if you are the one that you want to listen and write it down, the phone lines for phoning in to this show is 079 3293 4518. 079 3293 4518. Or I have a second number here, 0744 033 8623. I repeat, 0744 033 8623. These phone lines are also on the screen if you want to ask questions about any area of law that falls within my jurisdiction. Even if it's not immigration, I'm going to take my time to answer it. It's free legal hour. And if you have missed any part of this program, or if this whole program that I've done tonight is very exciting or insightful, remember, this program stays on City Media TV platform permanently. You can listen or watch it again, because this program is recorded and you can watch it again and again and again. Now it's the time whilst I'm waiting for anybody who have any legal question. I'm going to talk a little bit about City Law Solicitors, who we are and what we do. Now, City Law Solicitors is a solicitor regulated firm. You can find it at Barking. We are also family law accredited. In Barking, once you get to the station, that caller didn't come through. If you get to the Barking station and you want to know where City Law Solicitors is, you just turn right. Once you come out of the station, the train station, you find a KFC. You can just sit there and have some chicken. And when you are full, you can just turn right on the Cambridge Road, a bit way down to the traffic light. You find this beautiful building. You can find City Law Solicitors there. Unit 113 and 122 is the same offices. You find us there We specialize in this. I think I have a caller here. Hello. I think I have a caller here. If you can listen from the phone and mute your Facebook. Hello. You don't have to mention your name. You can just go ahead and ask your question. Or if you have want to make contribution, you can go ahead, please. And mute your Facebook. Hello. You don't have to mention your name. You can just go ahead and ask your question. Or if you have want to make contribution, you can go ahead, please.
Thomas.
Yes.
Please, I have a question for you. It's not about the 20-year rule. It's about naturalization.
Yes.
Please, I want to find out if I have divorced my husband, do I still have to wait for 10 years before I put the naturalization in? Do I still have to wait for 10 years before?
Okay, you need to mute your Facebook this time, mute it or listen to the phone so that you can hear me. Otherwise, there is a lot of echo coming from there.
Okay.
Yes.
I'll cut the Facebook so
that. All right. Yes. As I've said before, there is this good character requirement. It's been in place for some time. You need to show that when you are making an application for naturalization, that you will be here lawfully for 10 years. Unless you have what they call mitigating circumstances, good reason. And most times we've been able to show that people have had good reasons, and caseworkers take it into account. Now, to answer your question directly, I imagine you are talking about retained right because you are an EU former spouse, because you are divorced and you have retained your right.
Yes.
The point here is that even if you have retained your right, you still have to show, unless there is a good reason, that you'll be here legally for 10 years before you'll be eligible to make that application to naturalize. And normally for the EU citizens and their family members, in the past, if your spouse was exercising treaty right, so even though you are divorced, you probably have to check your date of marriage, and then you could look at whether at that date your spouse was exercising treaty right, which means that you from that date onwards you've been lawful. So I know your question is that you've been divorced, but you still have to check from your date of marriage and count from there to see whether at that stage falls within the 10 years and whether your spouse was exercising treaty right. If you are confused about it, then probably you need to look for a doctor to be able to diagnose that. Yes, but the starting point is showing that you'll be here lawfully for 10 years unless you have a good reason. And for those who have retained their right, the starting point is looking at your date of marriage and count from there whether you can get your 10 years lawful residence from there. Otherwise, if you don't give good reason, I know that most of those applications tend to be refused. Okay?
Oh, okay.
Yes.
Okay. Oh, I see. Okay, all right then.
So go and check your date of marriage and start counting from there.
Because it started from 2013 and this is the 9th year.
So you do have a problem there. So you see, it's not up to 10 years. But of course, you might claim that you were a partner, but obviously that might not work because even for those who are partnered, it's up to when the Secretary of State confirms that you're a family member. That's when your relationship becomes legal. So that's why they used to say confirmation of right as a EU family member. So, but you become a EU family member from the date of marriage. Okay?
Okay, all right.
All right.
Okay, thank you.
You are welcome. So I was just discussing who we are, City Law Solicitors. I'm still here to answer your questions. This is Free Legal Hour. We specialize in these areas of law. First, immigration, which is what I have been discussing tonight, in nationality and British nationality law. We can assist with this naturalization applications to register your child to become a British from the 16th of June last month, or children under the age of 18 who now want to register to become British, whether born here or born abroad, are now eligible to make application for fee waiver for their both parents to be assessed and means tested. And if they are successful, they can now get a fee waiver to make application to naturalize or to register to become British citizens. So we specialize in all those areas of law. EU law, we still dealing with the application for the settlement scheme. Those of you who have been refused, we're still dealing with all those cases. Employment law. Today, one of our clients was very happy. She had his competition for a case that was settled out of court. So if you have been unfairly dismissed, if you have become a victim of discrimination, if you have a settlement agreement, if you have been constructively dismissed, we specialize in employment law, and we do most of these cases on no win, no fee. And obviously, today I'm happy because we won the case. He had a share. City Law Solicitor, we also had our share. So I'm inviting all of you who have been unfairly dismissed, who have had bullying and harassment at your workplaces, who have had issues with discrimination, racial disability. We do all these cases on no win, no fee basis. And we can assure you that if you normally pick the case, you will get some compensation so that we can also get a token. Family law. If you want to have contact with your child arrangement order, I've always said here that under the Domestic Abuse Act 2020, it's now criminal offense to be a perpetrator. And therefore, if there is now molestation order or occupation order application in place, and you want us to defend you, we'll do that. If you are suffering from abuse, domestic abuse, and you want us to make application on your behalf so that you can remove that abuser from your life and get now molestation order in place or occupation order to remove that person from that dwelling place, again, we are here to assist you. We are family law accredited. So you can always dream of the best if we are dealing with your family law case. If you are going through divorce and you want us to assist you with your matrimonial matter so that you can get a better share of the contribution that you have made to the family pot, we will assist you to achieve that goal. Personal injuries and clinical negligence. We also specialize in personal injury and clinical negligence. If you have been involved in motor accident at the workplace, if you've gone for NHS treatment and you've had issues with the treatment and you feel that there is an element of negligence, again, we are here to do this case on no win, no fee basis. Commercial disputes and civil litigation, we are also here to take up your case. Those of you who are being pursued for debts in the civil courts, we are here to also assist you. Housing law, if your house is in disrepair state your landlord has failed to do that illegal eviction or unlawful eviction, we are here to support you if you have any of those cases that you want city law solicitors to assist you with. Consumer law, I've been here advising viewers freely of their right. The consumer law is just like the Bible. When you quote the monthly, I can give a testimony for myself. Recently, my TV, I have a brand new TV, the line on the consumer law. So, if you are insurance provider, want to wriggle out of that claim, if you bought a ticket, flight tickets, it's been cancelled, everything is in chaos, and you are not getting your refund, we are here to assist you. We deal with all matters under the consumer law. So, media and entertainment, we are also there to support clients in all these areas of law. So, it's been privilege to have you tonight. Before I go, I want to also give shout out to Yaro Man, who is also watching tonight. I have Kwesi Konadu Odum, who is watching tonight. Yellow Man says the best lawyer all time. Yellow Man, I'm aware that I have to finish your case. Wow. So guys, it's been a privilege having all of you here tonight. The 20-year rule, if you haven't I have Richmond Boaten, who is watching, Samuel Apoya, Tika Okpa Edward, all the way from Nigeria. It's a good job, sir. I have Patterson watching. I have Matthias Seika. I have Ebu Ed Bob Aka. Wow. Basti. Yes. So guys, it's been a good time having you here tonight. I am now bringing this program to a close on Thursday. We are going to be here again for the free legal hour. And this time MC Chaka will be here to host the show, and then we'll do the Chui section of this topic. I'm so happy that most of you join us tonight, but I want to urge you to also share the videos and spread the good news for those who are in the shadows, who have lived here for 20 years or less, who are petrified, and they feel that there is no hope, because these cases by their nature are complex. But that is why we are here to demystify the complexities and plead your case, so that case workers will have no good cause to refuse your application. Thank you so much for joining us tonight. God bless you. God bless you.